Hi there and welcome to Employment Hour in 30. I'm John Scholes. As always, my intrepid co-host, Lior Samfiru from the Samfiru Tumarkin law firm. This is Employment Hour in 30 where we discuss your workplace rights, a place where I think, sort of anecdotally, I mentioned a couple weeks ago, Lior, you spend about 80,000 hours of your life at work, right? That's a basic calculation for your average employee. So it's really important that you know your workplace rights, correct?
We spend more time at work than we do pretty much anything else.
Yeah.
We spend more time at work than we do with our family, doing our hobbies, on vacation. So it's extremely important that we know our rights, because if something happens in the workplace that impacts us, it's going to impact the rest of our lives. So we're here to talk about what the workplace rights are, to inform and educate people. That's really important stuff, John.
Week that was is how we always start. Some cases that you've been working on or have worked on in the past that are of some interest to people, yeah?
So I very much enjoy being here on TV, but I'm only here once a week for 30 minutes. The rest of my time, John, is spent in the office. I work with people, help people answer questions about workplace rights, and make sure that people understand what those rights are, and when needed, help them enforce those rights. So I want everyone to understand that the law, when it comes to employment law, is quite good. The law is very good. It provides some good entitlements that people have. A lot of people don't know what those entitlements are, and that is the purpose of this show. And to give you an example of that, let me tell you about a matter that came across my desk just a few days ago. I spoke with an individual that worked for 6 years part-time in a hotel. He had a job there, I guess, working at the reception and doing some other errands at the hotel. Well, he was let go because the company was cutting some costs, the company that owned the hotel. And what they told him is, because you're a part-time employee, you don't get any severance, but we're going to be nice to you. We're going to give you 2 weeks' pay out of the goodness of our hearts.
Wow, charming.
So he called me and he said, well, is this right? I am a part-time employee. I was, working 3 days a week, usually only. Does that mean I don't get any severance? But I've been working there for 6 years. So here's the thing, John. Part-time employees get the same severance as full-time employees. The law does not distinguish between full-time and part-time. So a person's termination entitlements, as I've said many times, are based on age, position, and length of employment. So whether you're a full-time employee or a part-time employee is not going to change that analysis. For this particular individual, he'd worked at a hotel for 6 years. He was in his 50s. For him, he would be looking at right around 8 months' pay, John. So again, part-time employee, 8 months' pay, not the 2 weeks' pay that the company wanted to give him out of the goodness of their hearts. And I see this all the time. Misconceptions, a big one is with respect to part-time employees. So the law, remember, is very clear. You get your full severance, always, even if you're a part-time employee.
And the sad thing is, if he had not, seen the show or called you, he might have walked away saying, wow, they're very nice. They gave me 2 weeks' pay.
A whole 2 weeks' pay.
Right.
And I'll give them the benefit of the doubt. Maybe I shouldn't, but I will, saying that they actually didn't know any better. And I see that very often. Don't assume your employer knows what the law is, that your employer knows what it owes you. In many cases, your employer may have the best of intentions, but may simply not understand what they actually owe you. It's your job as the employee to determine what is owed to you. It's your job to understand and enforce your rights. And in this case, it was a huge deal for him.
In addition to this show, of course, we do our weekly live radio show, take a ton of phone calls as we have for almost 5 years, I guess we're coming up on now. By the way, you want to go to hold of Lior anytime, 1-855-821-5900 is the number. We like to get some phone calls of interest and play them on the air here so you can get a little perspective. We'll get to one now.
I complained to my employer about working in a toxic work environment, and their reaction was just to get rid of me on the spot. Now I'm in a situation where they could probably owe me like 1 week severance, let's say. I could cause this company a bigger grief. It was a company where I know where major deficiencies were built, and I could just go and report, say, hey, we built a whole bunch of deficiencies. Can you just tell this company, hey, pay me a big severance package, and then I'll sign a non-disclosure agreement, and I won't rat you out?
I remember that.
Yeah, I remember that as well. I call it the blackmail phone call.
That's right.
Yeah. Well, let me address the legal issues, then I'll address the blackmail portion, if you will. So first of all, if you're subject to a toxic work environment, I think that's the language that he used, a poison work environment, I often call it, then that's obviously wrong. That's something that your employer should eradicate. Your employer should fix that problem. And you have every right to go to your employer and say, I'm dealing with harassment, I'm dealing with a poison work environment, please do something about it. And if your employer doesn't do something about it, or as this person says, they turn around and they let you go, because you had the audacity to raise that issue.
Yeah.
That's wrong. That's illegal. You're going to be owed significant compensation over and above the severance. So let's start with that. You should never have to tolerate a poison work environment. Now, beyond that, let's even talk about severance. Unless this person there started the day before, he's going to be owed a lot more than a week's pay. He said that, well, the company only owes me a week's pay. No. There's no way that a company is going to only owe him a week's pay. It could be a lot more than that. I don't know how long he'd work there. I don't know his job. But it's probably going to be measured in the months, not in the weeks, certainly not in the days. So right off the bat, the company actually may owe him a lot more than he realizes. So he may not actually have to blackmail them, quote unquote, to get what he's owed. Now, in terms of his question, I have all this dirt on the company. I'm going to use it unless they play ball. Obviously, that's wrong. That's also illegal. You can't blackmail someone, so we're not going to go there. And we don't need to go there, John, because the law is good enough as it is. If the company let him go because of a poison work environment and he raised that issue, that's illegal. That could be also a human rights violation. The company also owes him severance. So let's do this by the book. Let's get you what you're owed. You don't need to blackmail the company.
Now, he was pretty strong-willed in his comeback. People who are a little more sheepish, maybe, what's the first step they should be doing at the workplace? Because they're going to be intimidated, right?
Yeah. Well, I always say that if you're dealing with a poison work environment, try to resolve it internally, if at all possible. Many companies have an HR manager, or you may have a supervisor you can talk to, and try to resolve it. Now, if it's impossible because you've tried and you failed, or maybe the person that you'd go to is the one actually doing the harassing, then we can deal with it externally. Give me a call. Let's talk about that. In many situations, I can either give the company a kick in the pants and get them to fix the problem, or I can get you out of there, out of that poison work environment with compensation. But you have to give me a call first.
Help@employmenthour.com is the email address. Employmenthourtv.ca as well if you want to find out where the aforementioned radio shows are airing to catch one of those. You also get a ton of letters and phone calls at the firm. Interesting stuff, too. We call them employment scenarios. I'm going to read one to you now and let you expand on this, Lior. Zubair turns 65 next month. At his workplace, management tells employees who hit 65, this is a beauty, that the company is legally allowed to let them go because they've hit the official age retirement. That's nice. There's also a silver lining. Rumor has it that the company will hand you 2 weeks' pay. My cup runneth over. Paid in cash as a retirement severance. Because Zubair's worked there for, catch this, 28 years. Should he ask for a few extra dollars, week's pay maybe?
Yeah, well, I don't know if you could have read this in a more sarcastic way, John, but for good reason. So let's start with this whole 65 thing. So this company is about, I don't know, 12 years or so behind the times, because about 12 years ago, we've gotten rid of mandatory retirement. We got rid of this idea that a company can treat your employment as being terminated or retired at the age of 65. So the law is very, very clear. You can work as long as you want, whether it's 65, 75, or older. The company can't assume that you've retired. They can't make you retired. And, of course, they can't fire you because of your age. That's a human rights violation. So for this company to say, hey, you're 65, here's your retirement party, no. That's a human rights violation. That's a dismissal. It's a wrongful dismissal. And because they've dismissed this person, it's not 2 weeks' pay. I mean, if this gentleman worked there for all these years, he's going to be owed a lot more than that, potentially as much as 2 years' pay. So what I've done is I've taken this guy's scenario and I've inputted it into the severance calculator. We'll talk about it more in a second, but severancepaycalculator.com, and to find out how much this person would actually be owed. So I don't know his position, but let's say he's a supervisor, 28 years of service, at the age of 65, I'll put a number, let's say $70,000, and they say they're going to give him 2 weeks' pay. Well, he's owed 24 months' pay. 24 months' pay, John, as the calculator shows, and that's a difference of $137,000. So, wow. So I would have told them, use the severance calculator, severancepaycalculator.com. Call me. You can't be made to retire at 65. If you do, that's a human rights violation. That's a wrongful dismissal. You're owed severance, and don't let anyone tell you otherwise.
That number, by the way, 1-855-821-5900. Help@employmenthour.com. We've decided for this week to do some employment law, true or false. And it's not me asking the questions. In fact, I, for some reason, have chosen to be the sacrificial lamb on this one. So you're going to ask me.
I'm going to ask you some questions.
Because I have a law degree.
You don't have a law degree, but you know what? Neither do our listeners and our viewers. So I want to make sure that you've been paying attention over the past
5 years,
few weeks and 5 years we've been doing the show. So I'm going to start you off with some easy ones, and maybe they'll get a bit harder as we go.
I'm sure they will.
But you got a 50% chance of getting it right, Johnny. So true or false, John? I don't need a lawyer to help me get my severance. I can just call the Ministry of Labor.
Oh, come on. Low-hanging fruit.
Low-hanging fruit.
We know that's not right. You need a lawyer. You should have a lawyer.
That is false. But you know what? Our viewers may not appreciate that. You're right. That is completely false. And it's false because the Ministry of Labor, John, can only help you get your minimum entitlements, which could be a small fraction, a small portion of what you're owed. So you cannot contact the Ministry of Labor. And like I said, it sounds self-serving to say you need an employment lawyer, because I'm an employment lawyer, which is why I always say, that's fine. You don't like me, don't contact me, contact another employment lawyer. But you absolutely have to have an employment lawyer if you lost your job. You cannot, should not contact the Ministry of Labor. If you do that, you'll find out you give away your rights.
Right.
Bad idea, John.
Employment law, true or false? I'm ready for the next one. Bring it on.
So, my employer can fire me for any reason, whether it's to cut costs or because they want to hire someone else. Maybe I was late to work, or maybe I wore the wrong color socks. True or false?
I will say true under the caveat that they have to pay you full severance if they do so.
Okay, well, you know, my job here is done. I can now leave because I'm not needed.
See you next week. We're done here.
Well, here's the thing. That's absolutely right.
Yep.
Can your employer fire you for any reason or even a silly reason? The answer is absolutely yes, but as you've said, they have to pay you your full severance. A lot of people that call me are very upset that they lost their job. They feel they did nothing wrong, and they're right. But legally speaking, the employer can let them go as long as severance is paid. Now, and where a wrongful dismissal happens is that in many cases the employer does not pay proper severance, does not pay full severance, and they owe the person a lot of money.
Right.
But you're right, they can let you go for any non-discriminatory reason as long as they pay you severance, John.
And that's often the first part of the conversation you have is, okay, get over the fact that you've been fired. We can't do anything about that, but you should be looking at this number because that's where the error is, right?
I can't make your employer a better person.
Right.
I can't make them a more ethical person, but I can definitely make sure that you get what you're owed, that you get the compensation that you're owed. So that's where the focus has to be.
All right, employment, true or false, number 3.
All right.
2 for 2.
He's 2 for 2. Good. So the next one, John, is my employer can change my level of pay and workload whenever they want. Hey, they're the boss after all.
False. Right away, false.
That's good. That's good. That is false, John. That is false. Now, an employer does have some leeway to make some changes to your job. If they put you from Office A to Office B, that may not be a big deal. But if you're subject to significant changes to the terms of employment, that could be a constructive dismissal. That's something that the employer is not allowed to do. And if they do that, you may have the right to leave with compensation. So you're absolutely right, Johnny.
So far, I'm, 3 for 3 now?
Well,
this is better than when I was in school.
It's better. It's better. You're doing very well, John.
Thank you. Employment law, true or false, number 4.
4.
Bring it on.
So there's completely different severance rules for federally regulated employees.
False.
That's false. That is very false.
I totally guessed that one.
Another misconception.
Yep.
A lot of people believe that if I work for a federally regulated company, I don't get the same severance, or it's different, or it's less. Let's make it clear. Your entitlements are based on your age, your position, and the length of your employment. So whether you're working for a federally regulated employer, like a bank, for example, or a railway, or a provincially regulated employer, like most of us, you get the same severance. So don't assume that just because you're in a federally regulated company, you get less. Not true, John.
Doing the employment law, true or false here? It'll be a home game eventually, but we're just doing it on air now. Give me number 5.
Only 2 more, John.
Yeah, good.
So the next one, your employer has legal cause to let you go if your insurance provider, your disability insurance provider, cuts you off benefits.
No. False too.
False. That is very, very true. It's false. It's a big time false, because if your insurance company cuts you off, that's between you and the insurance company. That doesn't impact your job. If you have a doctor that says you cannot work, irrespective of what the insurance company does, your employer has to give you time off work. They can't fire you. They can consider you to have resigned. And if they do anything else, that's illegal. That's a human rights violation. And by the way, if your insurance company, if your long-term disability insurer cuts you off, give us a call as well. We deal with these issues all the time. The insurance company often is in the business of cutting people off, so we can get them to either reinstate you or pay you compensation. But your answer, John, correct.
And they quite often go hand in hand. Employment problems with insurance and disability problems, right?
you get cut off your insurance. The employer says you need to come back to work or else we fire you. They go hand in hand. We deal with both of these issues.
And just to make a finer point on it, the doctor's word is trumps all, really, when you can go back and not go back, right?
Yeah, your doctor decides. Your employer can't disagree. We'll talk about it a bit more later on the show. If your doctor says you can't work, you provide that to your employer, John. That's all you need.
Employment law, true or false? Final question. Bring it on. I'm ready.
Well, this one is not even fair because I talked about it at the beginning of the show. But part-time employees have a right to severance if they lose their job.
Oh, yeah.
It's true. I'm not going to elaborate. Part-time employees get the same severance as full-time employees based on age, position, length of employment. Check out severancepaycalculator.com. You get severance.
We'll take a short break. 1-855-821-5900 is Lior's number. EmploymentHourTV.ca. We'll get to the severance pay calculator and what to do when it comes to sick days in your workplace as well. Lots more. Employment Hour in 30 coming right up.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact: over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. Severance Pay Calculator. We make reference to it. It is something you should check out, you should know about, and we're going to elaborate about on it right now, Lior. What is it? How does it work?
Well, I referred to it before. I'm going to refer to it again because it's such an important tool. I created this tool that allows anyone to find out exactly how much severance they're owed if they lost their job. Severancepaycalculator.com is the address. Again, severancepaycalculator.com. And when you go there, John, you're going to be asked 3 simple questions: your age, your position, and the length of your employment. It's anonymous. You don't have to put in your name or the company's name. And when you answer those 3 questions, you're going to find out how many weeks or months severance you are owed. Make it a party game. Go around the room and find out how much severance everyone's owed. But it's important information to have. If you lost your job or if it's going to happen, and you don't want to be surprised with that severance letter and worry, wait a second, is that a good offer or a bad offer? You can find out at any time. And I promise you, it's a lot more than what you realize. Severancepaycalculator.com. If you use it, you won't lose money. You won't be taken advantage of. So always check out the severance calculator.
You know, we'll run through a sample here and see what you got coming off the back end of this one. It says, I'm 43. I was offered 4 weeks' pay after being fired from a sales job I was at for 2.5 years. Get those numbers. They gave me 2 days to sign the offer, but I missed the deadline. Am I out of options?
Yeah. So the deadline discussion is a very important one, John. Every severance letter has a deadline. But what is that deadline? It's a pressure tactic. That's all it is. The company wants you to feel that if you don't accept it by the deadline, you're going to lose something. Well, here's something you need to know. Those deadlines don't mean anything. Your legal rights don't expire in 2 days, 5 days, 10 days. You have 2 years to pursue those rights. So you have to get legal advice, whether it means going beyond that deadline. So why is it important for this person, the one you've asked us a question about? Well, let's put that information into the severance calculator. Again, severancepaycalculator.com. So a sales job, after 2.5 years of service, age of 43. Well, if they're offered 4 weeks' pay, as the person said, guess what, John? They were owed anywhere from 3 to 5 months' pay. So this person is worried about missing a deadline to accept a quarter of what they're actually owed. That happens all the time. 3 to 5 months' pay is what this person is actually owed, not 4 weeks' pay. That's why it's so important to get advice. That's why it's important to go to severancepaycalculator.com. And that's why it's so important not to be stressed out about that deadline. That deadline works well for employers. A lot of employees are going to feel that pressure and they're going to sign it under pressure. But despite that pressure, if you sign it, you're stuck with it. So severancepaycalculator.com, ignore that deadline, give me a call. Please don't accept a lot less than you're owed.
You know, a lot of our viewers may be thinking as well, okay, he mentioned he's in a sales job, and if it's 100% commission, their pay might go like this throughout the year. So how do you calculate that?
So when it comes to commission individuals, people that make what we call variable pay, pay changes, we simply look at an average. So if you're make an average a month $10,000 a month, then we're going to use that. We can go back 3 years, we can go back 2 years, depending on what's appropriate, but it's an average. And based on that average, we'll come up with a figure, and it's that figure that's used for the calculation of severance. But what's important for everyone to understand is that your commission is included in your severance. It is included. It's not just your base salary, your commission, your bonuses, your car allowance, your benefits.
It's all in there.
All of that has to be in there.
SeverancePayCalculator.com is what you want to check out anytime. It takes about 30 seconds to go through the program, and it's anonymous. You can just go away or click the button and contact Lior and the rest of the firm at that point. Phone calls, lots of them. EmploymentHourTV.ca if you want to find out where you can catch our radio program, the weekly radio program. Got lots of interesting calls on the show. We're going to play another one now.
My son came down with a condition and was hospitalized, and the company he was working for, he had been there 3.5 months, I guess, and they said he had accumulated so many sick days, so they fired him. I called the labor board, and they said, well, he was off over this. They have this 10-day limit, and once you accumulate 10 days, they can let you go.
Yeah, so Ministry of Labor, my good pals at the Ministry of Labor that give incorrect information. So that's not correct. If you are, in fact, legitimately sick, and if you're taking days off because the doctor says you need days off, and sometimes we go through bad periods and we need to take more days than we would otherwise, as long as it's legitimate, you can't be punished for it. Now, if the company legitimately doesn't have a job, okay, but they have to pay you full severance. You cannot be fired without severance because you took sick days. It's impossible. And depending on why you took sick days, if you took sick days because of a serious medical condition, that could actually be considered a disability. And if you have a disability, you absolutely cannot be fired. That's a human rights violation. So no, there's no way for a company to let someone go without severance because they took sick days, whether it's 1 sick day or 100 sick days. If the company lets you go, you get severance, and it's potentially a human rights violation. Just another example of why it's so important to get proper legal advice if you lost your job, regardless of the circumstances.
You can start with a simple email as well, help@employmenthour.com. You go to terminationquestions.com as well. We will get to that website and some questions when we take a short break. And the number 1-855-821-5900. Back with more Employment Hour in 30 right after this.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. If you've caught our radio show, if you haven't, you can go to employmenthourtv.ca to find out where you can catch that broadcast all week long. Phone calls, we get a lot of them, not only to the firm, but on the radio show as well. So we like to take the interesting ones, the interesting ones that'll give us some information, maybe some insight, and we play them for you on the show. Now let's get to another call, shall we?
Let's do it.
A friend of mine has worked for this company for about 27 or 28 years. Their company is going to close down, and what they've done is they've told them in November that they're going to close down next November. So they give them basically a year in advance notice that they're going to shut down. Do they still have to pay severance at the end of that, and what kind of severance would this guy be looking for?
That's a very good question.
Yeah.
It's an important question, and it raises this issue of notice of termination, advance notice. So if a company provides advance notice of termination, as long as it's in writing and as long as it has a specific end date, that notice counts towards severance.
Makes sense.
So if you got 6 months notice, that 6 months notice, as long as it's done properly, counts towards your severance. But let's talk about this specific situation. If he has worked there for 27 years and he got a year's notice, well, a year is not enough, which means at the end of the year, he's still going to be owed severance. So let's say someone after 27 years gets 24 months of severance. He got 12 months notice. which means at the end of that period, he's owed another year worth of severance. So if we were to put that in the severance calculator, we would see, again, severancepaycalculator.com, that this person is owed anywhere from 20 to 24 months pay. That he got 12 months notice. So he's owed anywhere from 10 to 12 months of pay. That's why it's so important, again, to get some advice and understand that just because you got notice, it doesn't mean that your rights to severance get eliminated. They may get reduced, and you would absolutely get severance. So this person should really give me a call as soon as possible, certainly before they're done working. If the company's shutting down, we want to make sure we deal with it while there's still a company there, before they disappear and move to a foreign country. Yeah, so your severance gets paid even if you got notice.
It's interesting, though. I wonder what the company's reaction will be, you know, if you knock on their door and say, here, guys, 1 year is sweet, but you still owe him another year. What did the company generally do? Just pay him right out, or just say, okay, that's fine?
Well, you know, it depends on the company. Yeah. Some companies, what they may do is say, well, you know what we're going to do? We'll extend your notice. At that point, which is not good, which is why what I usually like to do is I like to deal with these issues right at the end, when the person is just about to finish, when they can't extend it. But the good news is, John, in most of these cases, these matters are easy to resolve. They don't take long. They're not difficult. Oftentimes, a letter or two is all it takes. A lot of people decide not to pursue their entitlements because they're afraid of the process. They think it's going to take too long, it's going to cost too much, it's going to be complicated, it's going to go to court. None of those things are true. You're not going to be within 100 feet of a courtroom. It's not going to take long. Sometimes it could take a couple of weeks to resolve. So please don't be afraid of the process. Your rights are what they are. It's not complicated. It's not difficult to resolve. So don't let that stand in the way from you pursuing what you're owed.
Other than calling Lior and his partners at the firm or sending an email, there's also terminationquestions.com. It's a great place to ask your questions. Drop-down menu. Chances are, after this many years, your question has been answered with great detail. If not, you can go and lay it down there, and you'll get to answering some of those questions. I'm going to get to one and have you open up on this. My doctor says I need to be put on shorter shifts at work because of my illness. My employer doesn't agree with my doctor's orders and refuses to accommodate me until I get a second doctor's opinion. What do I do?
And this is, by the way, a question that we got submitted to us. This is a real question, and it makes me shake my head. And it makes me shake my head because what is this employer thinking? Who is this employer to say, I don't believe your doctor, I want another doctor? And what happens if he doesn't like that second doctor? He's going to get a third doctor's opinion? It's silly. So I've said this earlier in the show, I'm going to repeat it now. If your doctor says you can't work, or if your doctor says you need accommodation, the company has to do that. They have to give you time off work, they have to accommodate. So if the accommodation that your doctor says is shorter shifts, that's a reasonable accommodation. Your employer's going to have to do that. Whether it's modified duties, shorter shifts, change in work location, they have to do it. They can't decide they don't want to. They can't decide that it's not convenient, or let's hope that a different doctor is going to say something else. If your doctor is clear, if your doctor says what you need, now the onus shifts to your employer to do that. And if they don't, that's a human rights violation. A failure to accommodate is one of the most basic and most obvious human rights violations. If that's your situation, please do give me a call.
Terminationquestions.com is the website. We'll get to one more here. I think we have time. It says, after working 9 years for a company, over 6 contracts, my boss decided not to renew my contract. No explanation whatsoever. Your severance pay calculator suggests that if I was an employee, I'd be owed 9 to 12 months of severance. Do I get anything as a contractor?
Yeah, so, you know, quick answer here because we don't have a lot of time, but if you work for a company for 9 years, I don't care what you sign. I don't care how many contracts. You're an employee. Yep. And if your contract renews every year, it becomes meaningless. You're an indefinite, full-time, regular employee. So yes, you're an employee. This person is an employee, which means they're owed severance. Is a 9-year employee, they're going to be owed what a 9-year employee gets. It's so important to understand that it doesn't matter what you call yourself, and frankly, it doesn't even matter what you sign. You can't sign a document that says you're a contractor if you really are an employee.
Wow.
Otherwise, everyone would do it, right? So because of that, in this particular situation, it certainly sounds like this person is an employee rather than a contractor, that severance is owed, and don't let the company tell you otherwise. The company may think, you're a contractor, you don't get anything. Out the door you go. That's wrong, that's illegal, that's a wrongful dismissal, and should absolutely give me a call.
TerminationQuestions.com is our website. Again, drop-down menu, have a question. Chances are you've answered it. If not, it'll be answered very quickly. As we wrap for another week, some contact is 1-855-821-5900. That's Lior's number. Get a hold of a member of your team or you there as well. help@employmenthour.com. And we've mentioned it so many times in the show, you should have this on your tablet, on your desktop. Use it. It's free. It's easy. SeverancePayCalculator.com. Find out exactly what you're owed as far as your severance offer before you sign anything. And if failing that, give Lior a call, and he will set you straight for sure. Until next time, join us again. This has been Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.